Good morning, everybody. Can I first welcome the very small but select group who have been able to be accommodated here in Blackhall Place, and also, perhaps more importantly, welcome all of those who have joined us remotely through the wonders of the IT department of the Law Society here and Chute and her team. I hope this will turn out to be a very important conference and make a significant contribution to access to justice. And as many of you may know, I've returned to the theme of access to justice and barriers to that access on regular occasions during my term as Chief Justice. But it became increasingly clear to me that there's no single solution, there's no silver bullet. The range of issues that need to be addressed are wide, and the potential improvement that we might hope to bring about requires action across very many strands. And with that in mind, I established some time ago a working group, and I'm particularly grateful that the Free Legal Advice Centres, the Legal Aid Board, the Bar Council and the Law Society all agreed to participate in that working group and have made a great contribution to its work to date. And I would emphasise that it was never intended that that group would be fully representative of all of those who have legitimate interest in this topic. However, my view was that a small working group was a more effective way of dealing with matters. But recognising the need to widen the expertise and the viewpoints available, this conference was planned. And as our thinking developed, it seemed to us that there were really two very major strands to the debate. The first, which is perhaps a significant focus of today's plenary session, involves the response of existing institutions, whether that be government, the courts, or state bodies. Indeed, it was already clear that there were significant plans either being put in place or in the course of implementation by those institutions, which I think can have a real effect on improving access to justice. And I might say that the purpose of that aspect of the conference was perhaps to encourage those who have started those developments and hope that they will continue to be implemented and developed further as time goes on. But I think it also became clear to us that there was a second major strand which had perhaps not been the subject of sufficient attention to date. While it's easy to see how simpler court procedures, easier access to court systems, better legal aid and the like can make a real contribution, it also became clear that those measures, important and all as they are in themselves, would not be sufficient to provide anything like all the answers. For example, there are many who do not even know that there may be a legal aspect to the problems that they have and that the law might provide either solutions or at least an improvement in their situation. No matter how accessible our court system may be or how supportive a model of legal aid we might achieve, it's of little use if persons don't even know that there may be a legal solution to their problem in the first place. While the state and the courts have, of course, a significant role to play, there are others, including the practicing professions, who can bring their expertise to bear. And we were, of course, aware of programs designed to encourage lawyers to provide pro bono assistance, but we wondered whether that important resource might not be capable of being harnessed in a wider and more effective way. We also reflected on the fact that there are undoubtedly areas where the problems of access to justice can be particularly acute. Minorities, marginalised groups, vulnerable persons obviously run a real risk of having less effective access to justice than others. And also particular areas of the law throw up their own special challenges. We therefore decided to focus the second day of this conference on workshops designed to address specific issues with a view, hopefully, of identifying new and better ways in which we may be able in the future to widen access to justice in areas where it is currently particularly limited. At a very simplistic level, the purpose of today's plenary session is to encourage the continuation of initiatives adopted by major state bodies and to provide reasons why those initiatives make sense. The purpose of tomorrow is to help to build a roadmap for further and potentially more diverse actions which may need to be taken in the future. Now, I'm grateful that Minister Humphreys has accepted our invitation to speak today. Government can provide all of the solutions needed to improve access to justice, but many necessary measures just can't be advanced without significant government participation. For example, some of the streamlining of civil procedures recommended by the Kelly Review will require legislation. Much of the implementation of the Court Service Modernisation Programme will require resources. None of this can be done without government being on side. Indeed, I see an overarching theme of today's presentations as drawing attention to the interlocking nature of many of the questions which need to be addressed. I do welcome a number of significant initiatives taken by the government in recent times, and I leave it to Minister Humphreys to deal with the details. But the commitment to implementing the recommendations of the Civil Procedure Review, the funding of the Court Service Modernisation Programme, the programme for government's commitment to conducting a review of civil legal aid, and indeed the establishment of the working group now considering judicial numbers are all very valuable contributions. And in that latter context, I suppose one might say that it's one thing to have a good court system, but if there aren't judges there to hear the cases, then the rest will not be particularly effective. It, as scientists might say, it is a necessary but not a sufficient condition for proper access to justice. I, of course, accept that government does not have a bottomless pit of funds. The health service, education, and many other important aspects of our life have legitimate claims to enhance funding. However, I think it's important that the voice of the justice system and the need for enhanced access to justice has at least a seat at the table. I've commented before, but I think it is worth repeating that an analysis of what we spend on our justice system in Ireland, compared with comparators in the European Union and other countries which share a similar legal system to our own, places Ireland almost always at or near the bottom of the table. Now, I do accept that international comparisons aren't always easy. What counts as a judge in one state may be considered an administrative tribunal in another. Judicial numbers can be affected by factors such as, for example, the presence of lay magistrates in the United Kingdom system. And it's therefore not really possible to have exact comparisons. And I would therefore accept that if there were only modest variations in the numbers and sums of money spent, that could well be explained simply by different ways of counting. However, an overall view of the data seems to me to demonstrate two things very clearly. First, Ireland's position at or near the bottom of the table is so stark that it cannot be explained simply by differences in our systems or ways of counting. And second, and perhaps equally important, it's clear that taxpayers in countries in the common law system end up spending very significantly less on their justice system than is spent on behalf of the taxpayers in countries in the civil law system prevalent in continental Europe. It's beyond the scope of this short address to go into all of the reasons in detail, but it's fair to say that there is a significant shift in the common law system towards work being done by the parties and their lawyers, if they have them, as opposed to being done by the court and court staff and researchers. This significant difference has the effect of transferring cost from the taxpayer to the parties to litigation. And it is at least part of the explanation as to why the Irish taxpayer spends significantly less on our justice system compared with most continental countries, while the Irish litigant spends more. There are other consequences as well. It makes it harder for the unrepresented litigant in a common law system to deal with anything other than a very straightforward case. And the moral of this story, it seems to me, is that there is a strong case that some of the money that might have been spent had Ireland a judge-led civil law system, but which is saved by the taxpayer having a common law system, might be deployed to help those who could not reasonably be expected to adequately present their case without legal assistance and who struggle or find it impossible to afford it. That is perhaps a moral argument in favour of greater expenditure by our government on measures designed to facilitate access to justice. I recall just before the pandemic struck, when we were still able to meet people in face-to-face, and I'm very glad that we're beginning to get back to that situation, but I was speaking to some Slovak judges who are complaining, as judges throughout the world do, about the fact that there weren't enough judges to deal with all the cases that they had. But then I learned that Slovakia is about twice the size of Ireland in population, but there, from their point of view, inadequate number of judges was 12 times bigger than ours. Now, that doesn't necessarily mean that the Slovak system is better than ours, but it almost certainly reduces the burden, both financial and otherwise, on litigants. And the corollary is that there's a strong justification for saving some of the money, spending some of the money saved by our system on enhancing access to justice. But apart from that moral argument, there's a practical argument as well. We will have soon the benefit of hearing from Professor Trevor Farrow, who is a leading expert on the justification for enhanced access to justice. It seems to me that this provides a pragmatic complement to the moral argument. Frequently, we are faced in the world with dilemmas which stem from the fact that the right thing to do and the practical thing to do pull sometimes in slightly different directions. In my view, the data which Professor Farrow will present demonstrates that this is a case where the right thing and the pragmatic thing point in the same direction. Of course, the legal framework within which these issues arise is not just confined to our own national legal order under the Irish Constitution, but also has a significant potential to be influenced in the future by the jurisprudence both of the European Court of Human Rights, but also perhaps increasingly by the Charter in the way in which it comes to be interpreted and applied by the European Court of Justice. In that context, I'm particularly happy that we will hear from Judge Síofra O'Leary, who is, of course, a judge of the Court of Human Rights, but also worked for many years at a very high level in the Court of Justice and can therefore bring experience of both of those institutions to bear. In this legal space, we are not an island. And even those who are not persuaded by the moral argument or the pragmatic argument will have to take into account the potential effects of the case law of those supranational bodies of which we are members. And while acknowledging the highly interlocking nature of the issues which need to be addressed, I would not like it at all to be thought that I'm ignoring the very real part which courts, judges, and lawyers must play in finding and implementing solutions to the problem. In the very first address, which I gave at the beginning of the new legal year, just after my appointment as Chief Justice, I emphasised that we in the courts have a significant role to play, but that not all of the solutions lie within our hands. But that does not mean that we don't have a very significant role to play, and I'm therefore very happy that we will also hear from Angela Denning, the Chief Executive of the Court Service, about the role which the efficient administration of the courts can play in enhancing access to justice. Some of that action will, of course, interact with governmental measures, either requiring implementing legislation or the provision of resources. Yet another example of the interlocking nature of the necessary approach. But some of it involves things which we can do ourselves within the court system by changing rules or practices so as to make access to justice cheaper for those who are represented and potentially possible for the unrepresented, at least in a wider range of cases. And I would add that judicial training perhaps has a role to play in this. I'm happy to say that any difficulties that there may have been in providing adequate staff for the Judicial Council have now been resolved, and it will be possible to ramp up the very ambitious judicial training plans which the Judicial Director of Training, Judge Mary Osgoode, has evolved. Not all of that training will be to do with issues that might impact on access to justice, but some of it certainly will. There are many strands to the solutions which we need to find. We will play our role. The purpose of this conference is to bring together a range of influences, a range of viewpoints to hopefully work out a better plan for the future. While it's always wise for any judge to await the argument before reaching a final conclusion, I suspect that one of the themes from this morning will be that the major institutions involved are taking action, but that there is a long road to follow and much work still to be done. The consequences of not taking action will be significant. There's a duty on all of us to pull together to produce coherent interlocking measures to bring about a real improvement in the situation. But that another theme will be that there are very real consequences of not taking action, both legal, not least in the shape of the Court of Human Rights or the Court of Justice, or practical in the sense of the economic detriment which will be suffered by countries that don't address problems of access to justice. These are big picture issues, but they will, I hope, lay the ground for the more granular approach which we hope to see in tomorrow's workshops. But before handing over to our keynote speakers, I'd like to avail of this opportunity just to make a few personal observations. The first concerns access to justice in criminal matters. It has long been considered that the criminal legal aid system provides appropriate defence to those who are charged with significant offences, but who do not have the means to provide for their own legal representation. To a large extent, I think that continues to be the case. And that is why the principal focus of our conference over the next 2 days is on access to justice in non-criminal matters. However, I don't think that means we can be complacent. Like all systems, things change. Models which worked well in the past may cease to be fully fit for purpose. A number of criminal practitioners have recently drawn to my attention the fact that the disclosure obligations which now lie on the prosecution frequently involve defence legal teams having to go through volumes of documentation to ascertain whether any of it may be relevant to an upcoming trial. The digital age has created an exponential expansion in the volume of material that can frequently be available and possibly or potentially at least of some relevance to litigation. Indeed, that very problem has in many types of civil cases led to the well-known difficulties associated with the cost and complexity of discovery. The new criminal procedure regime will also need attention in the context of legal aid. I mention these matters simply to emphasise that we should not lose sight of the fact that the relatively satisfactory nature of criminal legal aid to date should not exclude a review of its continuing suitability for purpose in current and future conditions. Criminal legal aid is, of course, principally concerned with the provision of legal assistance to defendants in criminal cases. However, access to justice for defendants in civil proceedings is, in my view, every bit as important as access to justice for claimants. The defendant who is unable to properly defend proceedings because they're not of a type which they could reasonably be expected to do themselves without legal assistance, and where legal assistance is outside their means, is every bit as much a denial of proper access to justice as the claimant who cannot bring their case for similar reasons. Indeed, I would potentially go further. Parties, whether claimants or defendants, who are forced to settle proceedings on a basis that doesn't really reflect an appropriate assessment of the weight of their respective cases and the likely outcomes, can just as much be said to have been denied proper access to justice if the reason why they are forced into that type of settlement is because of the cost of the proceedings. Of course, we all want to encourage mediation, other forms of dispute resolution. We all favour the resolution of proceedings where possible by agreement, but a fair and just resolution of any legal dispute should be based on a genuine assessment of the merits of the case or any other relevant factors, not on the fact that one or other side can't afford to get proper access to justice. These issues can loom particularly large where there is a disparity in resources between the competing parties. A well-resourced party, whether claimant or defendant, may be able to exercise what I would call undue influence on the outcome of settlement negotiations precisely because they can afford to take a certain course which is not open to a poorly resourced opponent. That sort of situation can arise across almost the whole range of litigation and is, in my view, just as much a barrier to access to justice as more obvious impediments. For example, the small or medium-sized enterprise, which is forced to settle proceedings on terms much less favourable than a reasonable assessment of the case would suggest, and has to do so because it just can't afford to mount an appropriate defence, is just as much denied access to justice as a claimant with a good case which they can't afford to bring. Finally, it may be stating the obvious, but I'd like to return to a point which I made in that first address at the beginning of the new legal year in 2017. Not everyone may agree that our laws are ideal. And indeed, there may be competing views as to what fair and just laws should even look like. Not everyone may agree that all our judges are fair and competent, although I would like to say international assessments frequently place us in the upper range of the league table in that regard. However, even if our laws were universally considered perfect, and even if it was agreed that every judge in Ireland was the modern day counterpart of Solomon, it would little avail a party whose position those laws favoured if that party has not reasonable access to a court to ensure, if all other means of resolution fail, that their position is vindicated. It is to discuss that very issue that this conference has been called, and I'm very glad to introduce the first speaker, who will be Minister Humphreys. I've always said that I hate people who say someone needs no introduction and then proceeds to spend half the time of the forthcoming speech giving a long introduction. But I don't think we need an introduction other than to say that obviously Minister Humphreys is the Minister for Justice and Equality. And I hand over the floor to you, Minister, and thank you very much for agreeing to speak at our conference. Thanks.
Thank you very much, Chief Justice, and good morning, everyone. I'm honoured to join you today on the topic of improving access to justice. And I'm not just honoured to join you for this conference, but for one of your last official engagements, Chief Justice. And I've no doubt you're looking forward to a well-earned break after you stand down on the 10th of October. And you will, I am sure, have plenty of time to relax and indulge in some of your passions. Unfortunately, there are no race venues in my own county of Monaghan to invite you to, but of course there are plenty in Meath. And perhaps Minister McEntee, when she returns from maternity leave, would gladly host you for an afternoon's racing, and I would be very happy to attend too. On a serious note, Chief Justice, it is fitting that we are discussing access to justice at your seminar in the final days of your term. You've given the state great service, not least during the pandemic, as you steered the judiciary through the most difficult of circumstances, working closely with the court services. The last year and a half have been remarkably complex and important for us all at both the personal and professional levels, with the difficult impact of the pandemic coinciding with an ambitious modernisation programme for the courts. And I want to commend the judiciary and the entire staff of the court service for what has been achieved during this challenging period. I also want to personally commend the Chief Justice, presidents and all of the judiciary for the leadership you have shown in embracing the new practices and technologies that are at the core of modernising our justice system. On today's topic, I know, Chief Justice, that widening access to justice, removing barriers and improving processes are subjects that are very dear to you. It is also an agenda that is a priority for me as Minister for Justice, for Minister McEntee and for the government. Widening access to justice means many things. It means that all our citizens can readily access the legal system and services when they need it. This may be at times of difficulty in their lives or when they may be enforcing a contract or buying a home. But it also means ensuring that our legal system and the people working within it better represent the Ireland of today. As part of our overall plan to increase diversity across the justice sector, I firmly believe that there must be greater gender balance and diversity across the legal sector. We can achieve this through reform of legal education by breaking down barriers which prevent a wider pool of people entering the legal profession. These barriers that aspiring lawyers continue to face at the outset of their careers must be addressed for once and for all. Widening access to justice means additional judicial resources as well as reform procedures and work practices to reduce delays in our courts. It also means ensuring that those who need to access justice feel comfortable in engaging with our legal system, those who need resources to the family courts, for example, and victims of domestic, sexual and gender-based violence. It means embedding and building upon the many reforms implemented during the pandemic to achieve a truly digital-first legal system. Technology has played a significant role in keeping business going through the courts during the pandemic. In-court technology allows for the remote appearance of witnesses, prisoners and other parties to a physical courtroom setting, the digital display of evidence and digital audio recording of proceedings. Significant investment has enabled these new technologies to be installed in courtrooms around the country. And your modernisation programme continues apace and is a credit to all who work in the courts service. In acknowledging the achievements and new initiatives, I also want to commend the excellent cooperation that takes place on a daily basis between the courts and my department. We continue to appreciate the expert assistance and insights that you share with us on the daily operation of our judicial system. These are invaluable, not just in policy formation and in the preparation of legislation, but also in terms of maintaining public confidence and engagement in our joint endeavours. Legal aid is central to ensuring equality of access to justice, regardless of financial means. Justice Plan 2021, published by Minister McEntee, commits us to a review of the civil legal aid scheme this year. We have long held the aspiration that justice should be blind, not only in application, but in opportunity. In May, it was announced that the Legal Aid Board will no longer include the housing assistance payment in their calculation of entitlement to civil legal aid. This will have a positive impact for those who are of modest means and are in receipt of HAP or any other housing support measure provided by a government department or any other public body. The general scheme of a criminal legal aid bill is being prepared and it will transfer the administration of the criminal legal aid scheme to the Legal Aid Board. The report of the review of the administration of civil justice, chaired by Mr. Justice Peter Kelly, made over 90 recommendations across a range of areas to strengthen the administration of justice. I have no doubt that when implemented, these recommendations will transform the civil justice system for those who work within it and people who use it. An implementation group has been established to oversee and monitor execution of the recommendations. An implementation plan is being finalised and I will bring it to government and publish it by the end of the month. And I can tell you today, however, that some of its key actions include legislation will be brought forward by my department to reform judicial review, discovery, multi-party actions and changes to improve court procedures. A programme of standardisation and simplification of court forms and wide-ranging operational changes to how the Irish courts are run, including providing more information to litigants without legal representation and a comprehensive update of the court IT systems. As I mentioned earlier, tackling the scourge of domestic, sexual and gender-based violence is a priority for me, Minister McEntee and the government. We have had lengthy discussions at Cabinet on the issue and everyone, including the Taoiseach, is determined to help victims and get tough on perpetrators. Minister McEntee's Supporting a Victim's Journey plan is a detailed roadmap on how to implement the recommendations of the O'Malley Review. Supporting a victim's journey will protect and support vulnerable witnesses during the investigation and prosecution of sexual offences. We are working to create a system that supports victims and empowers them to report offences, knowing they will be supported, informed and treated respectfully throughout the criminal justice process. We hope to provide for court procedures that support a faster and less adversarial resolution of family law disputes in specialised centres. One of the plan's key recommendations is the development and rollout of training for all personnel a victim may come into contact with as they navigate the justice system. This includes An Garda Síochána, the Director of Public Prosecutions, the legal profession and the judiciary. It is recommended that all judges presiding over criminal trials for sexual offences and all lawyers appearing in such trials should have specialist training. I know training has already begun under the Judicial Council, and I urge all members of the judiciary to avail of this training as soon as possible. Separately, the Bar of Ireland's existing continuous professional development programme incorporates training for barristers dealing with vulnerable witnesses. In September 2020, Government approved the drafting of a family court bill to provide for the establishment of a district family court, circuit family court and a family high court as divisions within the existing court structures. The general scheme of the bill is awaiting pre-legislative scrutiny by the Joint Oireachtas Committee on Justice. The drafting of the bill will be progressed as a matter of urgency with a view to the bill being published by the end of February 2022. I believe these are landmark reforms which will develop a more efficient and user-friendly family court system that puts families at the centre of its activities, provides access to specialist supports and encourages the use of alternative dispute resolution in family law proceedings. The development of sensible, comprehensive and sensitive family law procedures, particularly for vulnerable families, will be central to the new system. When we speak about widening access to justice and breaking down barriers, Chief Justice, reforms such as these are exactly what we mean. These reforms will be supported by the construction of a purpose-built family law court complex at Hammond Lane. Hammond Lane is a key project in the National Development Plan, and I know it is the priority project of the court's service. We hope construction will begin in 2023 and the doors of the complex will open in early 2026. In order to help the courts deal with the COVID backlogs and address areas of immediate need, the Government recently approved the largest increases in the number of judges in living memory, and I know this was welcomed by many of you. The 5 extra judges will also help with Ireland's participation in the Schengen Information System and strategic infrastructure development issues. I was also pleased that in broader terms, a judicial planning working group has already convened to review the number and type of judges required in the coming 5 years. The group will also examine other areas such as work practices. This is in line with the commitment in the programme for government to consider the number of and type of judges required to ensure the efficient administration of justice over the next 5 years. The group is to report in the spring of 2022. I have also commissioned the OECD to prepare an independent review of the judicial resource needs, including benchmarks against international comparators, so that we have the numbers, the skills and the processes to ensure access to justice over the next 5 years. And I expect that report to be complete within the year. The coming year will also see us hopefully enact the Judicial Appointments Commission Bill to bring greater transparency to the system of appointing judges. The Government approved the general scheme of the Judicial Appointments Commission Bill in December 2020, and the bill is at an advanced stage of drafting. The new bill will put the Chief Justice at the head of the new commission, and it will replace the Judicial Appointments Advisory Board. There will be an equal number of laypersons and judges, and the Attorney General will be a member in a non-voting capacity. Chief Justices have chaired the Advisory Board for 25 years, and retaining this ensures that the selection process is absolutely rigorous and meets the need to have a strong, independent judiciary. All persons who wish to be considered for appointment to the judicial office, including serving judges, will be required to apply to the Commission. No other process will be in place. The Commission will assess and deal with applications from serving judges and develop appropriate procedures for their assessment. I believe the bill will deliver substantial reform, providing for a modern and transparent system to deal with judicial appointments in the state. In considering access to justice, we must also be frank. Legal costs in Ireland are prohibitive and act as a barrier to people to exercising their rights before the courts. My department issued a request for tender for research to undertake an economic analysis of models or approaches to reducing litigation costs in Ireland. As you are aware, the Kelly Review Group was split on whether scales of costs should be binding or non-binding. The research is expected to assess which of these approaches or others it might identify will achieve the aim of reducing costs for legal service users, citizens, businesses, as well as costs to the state. The tendering process is still ongoing and is expected to award the contract to a successful bidder in the coming weeks. Once this research is complete, my officials will consider its findings and use them to inform the development of proposals in this area. Moving back to the work of the Judicial Council, I am happy to note that under the stewardship of the Chief Justice, the work of the Council is progressing steadily and instilling confidence in its work. It is particularly worth noting the extent of the tasks which have already been undertaken, including the adoption of personal injuries guidelines and the extensive work which has been taken across all jurisdictions in the training of judges by judges. The Judicial Conduct Committee was formally established with effect from the 30th of June 2020, and I understand submitted draft Judicial Conduct and Ethic Guidelines to the Board on the 28th of June as per the Judicial Council Act 2019. The Act further states that the Council must then adopt those guidelines within a further 12-month period from that date. Once the guidelines are in place, the Minister for Justice will then make orders bringing into operation those relevant provisions of the Act which have not yet been commenced. I acknowledge the commitment of all involved in the Judicial Council, and I look forward to ongoing developments in its work. Before I conclude, I would once again like to pay, in particular, tribute to the Honourable Mr. Justice Frank Clark. As Chief Justice and as a judge of the Supreme Court and High Court, he is given a distinguished career of public service. He leaves a proud legacy of achievement. The Honourable Mr. Justice Frank Clark's work has been of great importance and relevance to the citizens of the state. His leadership, direction and innovation, in particular, as I said, in the light of the COVID pandemic, has ensured that access to justice, particularly for the most vulnerable in society, was maintained. As I noted, Chief Justice Clark's substantial role in the establishment of the Judicial Council was essential and has paved the way for the support of and continued excellence among the judiciary in the future. He has also been the first chair of the Advisory Committee on the grant of patents of precedence, which has modernised the path to becoming Senior Counsel. The Honourable Mr. Justice Clark's progressive vision and guidance in his role as Chief Justice has been an impetus for great change, progress and modernisation now and for the future. Despite the immediate challenges of recovery and adjustment to the pandemic, the judiciary and court service have now set a path for the future of the court system that continues to uphold the importance and centrality of access to justice. We in government will support you through the reforms and initiatives to which we are committed to in the Programme for Government and Justice Plan 2021. Thank you.
On the part of the Department of Justice and the government to the measures which are already in place. Our next speaker again is someone who requires no introduction. She is the judge nominated in the Irish interest, as it were, on the Court of Human Rights, Judge Síofra, and I hand over the floor to her. Thank you very much.
Thank you very much, Chief Justice, Minister Humphreys, ladies and gentlemen. My very warm thanks to the Chief Justice for this invitation to address you and the very important topic of access to justice, providing some European legal context. 2 years ago, on the occasion of a FLAC conference marking the 40th anniversary of Éirí against Ireland, which, as you know, was a landmark Strasbourg judgment, and I'll return to it briefly later, I noted the long-standing judicial and extrajudicial commitment of the Chief Justice to the questions before us today. And you've been reminded this morning that since he took up office, he has placed this issue squarely at the heart of his extrajudicial pronouncements. Access to justice has also been at the forefront in leading cases in recent years in both this and in the neighbouring common law jurisdiction. In Ireland, for example, in SBV Osus Limited, a case decided in 2018, the then Mr. Justice Clark stated, and I quote, "I remain very convinced that there are cases where persons or entities have suffered from wrongdoing, but where those persons or entities are unable effectively to vindicate their rights because of the cost of going to court. And it does seem to me that this is an issue to which the legislature should give urgent consideration." And across the water, prior to becoming president of the UK Supreme Court, Lord Reid expressed similar concerns in a unanimous judgment delivered in our unison against the Lord Chancellor. And an extract from his judgment is, I think, worth citing in some length because it conveys a very simple but essential message. He stated, and I quote, "Courts exist in order to ensure that the laws made by Parliament and the common law created by the courts themselves are applied and enforced. That role includes ensuring that the executive branch of government carries out its function in accordance with the law. In order for the courts to perform that role, people must in principle have unimpeded access to them. Without such access, laws are liable to become a dead letter, the work done by Parliament may be rendered nugatory, and the democratic election of members of Parliament may become a meaningless charade. That is why courts do not merely provide a public service like any other. Access to the courts is not," he continued, "therefore of value only to the particular individuals involved. And that's most obviously true of cases which establish principles of general importance. Because every day in the courts and tribunals of this country, the names of people who brought cases in the past live on as shorthand for the legal rules and principles which their cases established." An excellent example of this type of groundbreaking litigation in Ireland is State Healy against Donoghue on the constitutional right to legal aid in criminal cases referred to by the Chief Justice. And this was a case in relation to which a young John McMenamin, who I know is here with us today, is reported by the Shanakees of the Four Courts to have advised the plaintiff's mother from a FLAC centre in Tala. But there are many other more recent examples. For example, State Houlihan against the Minister for Social Welfare, or indeed McCann against the judges of Monaghan District Court on the question of imprisonment for failure to pay a debt, a subject which has been the issue of extensive Strasbourg case law. As an aside, the prominence given to questions of access to justice on these two islands in recent years could perhaps lead us to reflect over the weekend on the possible particularities of the common law when it comes to practical obstacles to access to court, or indeed the particularities relating to the organisation or cost of the two legal professions which serve the common law systems, a point just referenced by the Minister. My role this morning is, I think, a little bit different to that of other keynote speakers, as I intervene not from a domestic perspective, but from the perspective of someone who has worked in European law for several decades. Starting with the Airy judgment and moving forward with reference to the development of the European Convention on Human Rights and EU law, I hope to feed into your conversation on how to shape Irish law and access to justice for the future, while of course fully observing the limits of what a sitting judge can actually say. The Airy judgment is now almost 43 years old. While excluding the existence of a right under Article 6.1 of the Convention to free legal aid in all civil cases, the court held that an individual should enjoy an effective right of access to the courts in conditions not at variance with Article 6, paragraph 1. And the Airy judgment was itself the consequence of the Strasbourg Court's previous finding on access to court 4 years previously in Golder against the United Kingdom. Article 6.1 of the Convention does not expressly provide for a right of access to courts or tribunals. However, in Golder, the Strasbourg Court held that the express rights to fair, public and expeditious proceedings under Article 6 would have no value if there were no access to courts and therefore no such proceedings to begin with. As many of you will recall, when she introduced her Strasbourg application in 1973, Joanna Airy complained that due to the prohibitive cost of the proceedings in the Irish High Court, she couldn't obtain a judicial separation. And crucially, thinking with the Chief Justice's identification in the concept note of both formal and practical obstacles to access, the Strasbourg Court established the following key legal principles. Firstly, hindrance in fact contravenes the Convention in the same way as a legal impediment. And secondly, fulfilment of a duty under the Convention can on occasion necessitate some positive action on the part of the state. By 5 votes to 2 in that case, with the then Irish judge dissenting, the court held in the Airy case that Article 6, paragraph 1 may sometimes compel the state to provide for the assistance of a lawyer when such assistance proves indispensable for effective access to court, either because legal representation is rendered compulsory, as is done by the domestic law of certain states for various types of litigation, or because of the complexity of the procedure or the case. It was not, the Strasbourg Court stressed, its function to indicate, let alone dictate, which measures should be taken to comply with the state's positive obligations. The institution of a legal aid scheme was mentioned as one possibility, and a simplification of procedure was mentioned as another. The consequences of the Airy judgment in Irish law were immediate, with the establishment of the Civil Legal Aid Scheme, a legal aid board and law centres. And the merits and demerits of the system, which has operated ever since, are well known to a domestic audience and will be discussed, no doubt, today and tomorrow by other participants who are better qualified to develop on them further. Fast forward from Airy, and Mr. Justice Kelly's review of the administration of civil justice, which has already been mentioned, has sought, amongst other things, to tackle questions of simplification of procedure, outdated and excessively complex procedural rules. But these things, it should be stressed, were flagged by the Strasbourg Court as possible hindrances over 42 years ago. And as an aside from the Strasbourg Court, I should say that I work in a jurisdiction which has for over a decade engaged in extensive intramuros judicial and procedural reform, reforms which go very far, but which reach their limits when the court in question is lacking in essential resources. Now, what does the post-Airy Strasbourg case law tell us about access to justice generally and the existence and nature of a right to legal aid in particular? The European Court of Human Rights has reiterated on numerous occasions that the right of access to court under Article 6 is not absolute. Whether and when Article 6 implies a requirement to provide legal aid will depend, among many other factors, on the importance of what's at stake for the applicant's vulnerability, the emotional involvement of the applicant, which may impede the degree of objectivity required by advocacy in court, the complexity of the relevant law or procedure, something which the Chief Justice has highlighted as having increased in recent years exponentially, the need to establish facts through expert evidence and the examination of witnesses, the applicant's capacity to represent him or herself effectively, and the existence of a statutory requirement to have legal representation. The fact that the convention right in question is not absolute means that it may be permissible to impose conditions on the grant of legal aid based on considerations relating to the financial situation of the litigant or his or her prospects of success in the proceedings. Legal aid schemes which select the cases which qualify for legal aid are therefore considered justifiable, but provided that they offer individuals substantial guarantees to protect them from arbitrariness. In Airy, as I just indicated, the court had emphasised that it was not for an international court to decide how a state should respond to its obligations under Article 6 of the Convention. And there'll only be a violation of Article 6 where the very essence of the right of access is impaired. In a UK case, PC and S, for example, involving childcare proceedings, the court acknowledged, and I quote, "Although the pursuit of proceedings as a litigant in person may on occasion not be an easy matter, the limited public funds available for civil action renders a procedure of selection a necessary feature of the system of administration of justice." Now, according to the Strasbourg Court, that difficult selection procedure falls to the state, and it will not raise a difficulty with reference to the Convention, provided, however, they do not act arbitrarily or disproportionately. The question in an Italian case, a case called Angel against Italy, was the extent to which the state could be held responsible for the quality of the legal assistance provided under the legal aid scheme it had established. As a general principle, of course, and given the independence of the legal profession from the state, the court pointed out that the conduct of a case is essentially a matter between the defendant and his or her counsel, whether counsel be appointed under a legal aid scheme or be privately financed. But in Angle, although the legal aid lawyers had been provided, they had offered erroneous advice and their errors had not been remedied by the domestic authorities, resulting in a lack of practical and effective representation. In a case from Armenia, Shamoan, the Court of Human Rights was receptive to the applicant's argument that in the light of her difficult financial situation, the absence of both legal aid and of evidence that counsel may be willing to act pro bono, the government's non-exhaustion objection could be dismissed. And it's worth pausing and reflecting on what the absence of effective access at national level may entail in terms of the broader convention system in which I work. The convention system is predicated on the protection of fundamental rights by national courts, with the Strasbourg Court merely acting as a safety net. And as my UK colleague Tim Eike has observed, cases like Shamoan highlight the risk that practical as well as formal barriers to access to justice at national level, whether or not they are eventually found to violate Article 6.1, could increase the likelihood that non-exhaustion objections will be rejected by the Court of Human Rights. And this in turn would mean that the principle of subsidiarity, the repetition of responsibility between the national courts and the Strasbourg Court, could be undermined. Other obstacles to access to court may be created either by the actual costs incurred in the course of litigating before the domestic courts, or the deterrent effect likely or possible which cost exposure may have on applicants. And this issue has been considered by the UK Supreme Court in a case called Coventry against Lawrence. In that case, by a majority of 5-2, that court held in 2015 that the system for the recovery of costs in civil litigation in England and Wales under the Access to Justice Act 1999 is compatible with Article 6 of the European Convention. The AGA regime deliberately imposed the costs of all conditional fee agreement litigation on unsuccessful defendants as a class. Instead of placing a burden on the legal aid fund, legal proceedings were to be funded by a party's lawyers who would undertake the work on risk in exchange for a potential success fee. If the proceedings were successful, the burden of the success fee would be transferred to the losing party. In Coventry, the United Kingdom Supreme Court majority stated that the Article 6 question before them was not whether the AGA regime had flaws, it was rather whether it was a proportionate way of achieving the legitimate aim it pursued, namely the widest possible access to legal services for civil litigation funded by the private sector. The UK Supreme Court gave considerable weight to informed legislative choices in circumstances where state authorities are seeking to reconcile the competing interests of different groups in society. And it held that there is a powerful argument that the 1999 Act is compatible with the Convention simply because it is a general measure which was justified by the need to widen access to justice to litigants following the withdrawal of legal aid, was enacted following wide consultation, and it fell within the wide area of discretionary judgment of the legislature and rulemakers. Now, the scheme as a whole was therefore considered by the majority to be a rational and coherent means to provide access to justice. But this and another UK case touching on a similar issue subsequently made their way to Strasbourg. One of the two cases has already been rejected for non-exhaustion reasons, but Coventry is still pending, so that is perhaps a case to watch. Both UK cases remind us of the door opened by Joanna Airy in the 1970s and the distance travelled since. Many violations of Article 6 of the Convention have been found since the Irish case, with the Court of Human Rights on occasion, as I said, looking into the quality of a contested legal aid scheme and relying on principles of fairness. However, as you well know, in its protection of essentially civil and political rights, the Strasbourg Court treads very carefully when it comes to the social and economic consequences of its decisions, or when its decisions engage with highly technical areas of national law, themselves the product of national social and economic policy choices. As emphasised in the UK case I cited earlier, PC and S, the limited public funds available for civil actions may render a procedure of selection a justified feature of the system of administration of justice. and this may be the Achilles heel for those who seek further or far-reaching developments at Strasbourg level, but I'll return to this point a little bit later. Turning to the law of the European Union, what grounds, if any, does the latter provide to those seeking to redress access to justice problems in their national systems? Well before the 2009 Treaty of Lisbon and the EU Charter, the Court of Justice in Luxembourg had recognised the principle of effective judicial protection as a general principle of EU law, stemming from the constitutional traditions common to the Member States, an important point which is sometimes forgotten, and from Articles 6 and 13 of the European Convention on Human Rights. This principle is now reaffirmed in Article 47, paragraph 1 of the EU Charter, which provides that everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal. In addition, Article 47, paragraph 3 of the Charter provides that legal aid, and I quote, shall be made available to those who lack sufficient resources insofar as such aid is necessary to ensure effective access to justice. And the explanations which accompany the Charter and which are used by the Court of Justice as an aid to interpretation refer expressly to Airy and Article 6 of the European Convention in support of this. In addition to Article 47 of the Charter, it should be remembered that EU member states have always enjoyed a degree of autonomy in relation to the detailed procedural rules at national level governing actions for safeguarding an individual's rights under EU law. However, according to well-established Court of Justice case law, those rules must be no less favourable than those governing similar domestic actions. This is referred to as the principle of equivalence, and they mustn't render practically impossible or excessively difficult the exercise of rights conferred by EU law. This is referred to as the principle of effectiveness. And these principles are often treated nowadays as the concrete embodiment of effective judicial protection at domestic level, and they're relied on frequently by the Court of Justice. Before looking at how EU law, the Charter and the Court of Justice are now approaching questions relating to effective judicial protection, access to court and legal aid, I think it's very important to remember the central place accorded the preliminary reference procedure in the EU legal order. The EU's judicial system, as conceived by the treaties and as interpreted by the Luxembourg Court, has as its keystone the preliminary ruling procedure. So while responsibility for ensuring observance of the law in the interpretation and application of the treaties falls to both the EU and national courts, restrictive rules on standing for individuals before the European Union courts mean that in reality, the EU is largely dependent on national courts to ensure respect for the principle of effective judicial protection. And it's through national courts and via the preliminary reference procedure that the observance of EU law is primarily guaranteed. And as a union based on the rule of law, the EU requires that individuals have a right to challenge before the courts the legality of any decision or other national measure concerning the application to them of an EU act. For the purposes of our discussion, this raises an important question. If national courts are the fora in which to ensure EU law is correctly applied, how do you ensure effective access to national courts in the first place? Post-Lisbon, some EU law cases stand out in terms of access to justice and a right to legal aid, not least a German case called Deb. The judgment in Deb was delivered in December 2010, just over a year after the EU Charter had acquired the same legal status as the treaties by virtue of Article 6, paragraph 1 of the Treaty on European Union. Deb was a German company which wished to bring an action for damages before the German courts against the German state in order to obtain what are called Frankovich-type state liability damages as a result of the state's delay in the transposition of a directive. The Court of Justice was asked whether the fact that a legal person in this case is unable under national law to qualify for legal aid rules renders the exercise of its rights impossible in practice. On the question referred, the Court of Justice held first, after a more than extensive usual review of Strasbourg case law, that the grant of legal aid to legal persons is not in principle impossible pursuant to the EU principle of effective judicial protection. Next, it explained that it's for the national court to ascertain first whether the conditions for granting legal aid constitute a limitation of the right of access to courts which is liable to undermine the very core or essence of the right. Second, whether those conditions pursue a legitimate aim. And finally, whether there's a reasonable relationship of proportionality between the means employed and the legitimate aim pursued. So you see the Luxembourg court transposing to its own case law, essentially the Strasbourg test. The Court of Justice in Deb also detailed the factors that a national court may take into account. And again, the factors to be considered will be very familiar to Strasbourg observers. It indicated that the national court must look at the importance of what's at stake, the complexity of the applicable law and procedure, and with regard specifically to legal persons, their form, and whether they are profit-making or non-profit-making, as well as the financial capacity of partners and shareholders. The particular difficulties encountered under national law by legal aid claimants, which are companies relying on EU rights, were noted by the Court of Justice, which stated as follows: it is for national courts to strike a fair balance in order to ensure that applicants relying on EU law have access to the courts, but without favouring such applicants over others. In a later case, Commission against France, on whether a reduced VAT rate provided by French law for lawyers was EU VAT compatible, the Advocate General noted that the objective of promoting access to justice and the law in general for persons with insufficient resources is in accordance with the fundamental values of the system of judicial protection prevailing within the European Union. And this really highlights the point made by the Chief Justice this morning in his introduction, that the subject on your table this weekend is not simply a domestic subject, but it's one with reference to which European law has a very significant role to play. It's also worth remembering that in the EU context, a specific model to keep costs low and facilitate access has developed in the environmental field, pursuant to the Aarhus Convention and EU directives adopted thereunder. Those rules require review procedures for environmental claims to be fair, equitable, timely, and not prohibitively expensive. And it's noteworthy that in the UK, in his 2017 supplemental review on civil litigation costs, Lord Justice Jackson proposed extending claimant-friendly rules which apply to environmental claims to all judicial review claims. And I note that the environmental panel chaired by Professor Anya Ryle tomorrow will discuss the environmental field and perhaps will have some lessons and pointers which they might share with other delegates. Returning to the general principles of EU law, in the case law of the Court of Justice, the right to or principle of effective judicial protection has become inextricably linked in recent years with the more general principle of what is called EU law effectiveness. And this leads us to a key and new player in the field, Article 19, Paragraph 1 in the Treaty of European Union. This article, in its second sentence, provides member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by union law. According to the President of the Court of Justice, Kuhn Leonards, this provision ensures that the substantive rights which EU law confers on individuals do not become an empty promise. By virtue of that principle, in the absence of EU measures harmonising national rules of procedure, it is for the member states to ensure the full effect of EU law. Now, this seemingly innocent sentence in Article 19, Paragraph 1 has gained particular importance in recent cases, many of which you will know. The first involved Portuguese judges, and subsequently and more frequently, cases have involved the recent reforms of the Polish judiciary. And in these cases, the Court of Justice has transformed Article 19, Paragraph 1 into a judicially enforceable rule of law clause. Article 19, Paragraph 1 bolsters and supplements Article 47 of the Charter, but also to some extent it supplants it. The reason for this is that the latter applies within the narrower, albeit still broad scope of EU law, whereas Article 19, Paragraph 1 of the Treaty on European Union applies in all the fields covered by EU law. Article 47 of the EU Charter provides effective judicial protection only when individuals seek to take advantage of specific EU provisions. Those provisions constitute the link or connection which brings an applicant's case within the scope of application of EU law and, if you like, outside of the scope of application of purely national law. But Article 19, paragraph 1 applies more broadly. It applies to courts and procedures which function within the fields covered by EU law, essentially most courts and procedures, and its potential effects for a national judicial system may therefore be much broader. In the infringement action involving Polish judges, which was decided in June 2019, this became very clear. Rejecting Poland's arguments to the effect that organisation of the judicial system was a national and not an EU competence, the Court of Justice held, and I quote, although the organisation of justice in the Member States falls within the competence of those Member States, the fact remains that when exercising that competence, the Member States are required to comply with their obligations deriving from EU law. In addition, via Article 19, paragraph 1, the principle of effectiveness, which was originally born of Member States' procedural autonomy, is interpreted by the Court of Justice as giving rise to obligations, and potentially far-reaching ones, regarding access to justice, fair procedures, and judicial independence. Of course, it could be argued that the Court of Justice recent case law that I've been referring to is concerned principally, if not exclusively, with such questions of judicial independence. However, the central reliance placed by the Court of Justice on Article 19, paragraph 1, the broader scope now given to that manifestation of the principle of effective judicial protection, and the very terms of the Court of Justice's judgments make it possible, if not likely, that broader questions relating to organisation and procedure in Member States' judicial systems will fall within the remit of Article 19, paragraph 1. And this also brings me back to the preliminary reference procedure as the keystone of the EU's legal order. For that procedure to fulfil its role, individuals have to have access to courts. As I suggested at the FLAC conference in 2019, the following question does seem to arise. Does Article 19, paragraph 1, combined with Article 47, paragraph 3 of the EU Charter, now provide individuals with fertile ground in a wide variety of circumstances and in fields covered by EU law to argue that in the absence of legal aid, that access is disproportionately or unfairly restricted? That's a question I raise, but it's luckily a question that I don't have to answer. A final note on actual and potential differences between the European Convention on Human Rights and EU law in relation to legal aid brings us back to the characterisation of the right to legal aid and consideration by European courts of the economic consequences of granting it. In Erie against Ireland, we saw the European Court of Human Rights broaching it as a qualified right, stemming from states' positive obligations with implications of a social or economic nature. In that 1979 judgment, the Strasbourg Court stated, "The Court is aware that the further realisation of social and economic rights is largely dependent on the situation, notably financial, reigning in the state in question." And as I explained earlier, in terms of financial means tests, the European Court of Human Rights has said that there will be no violation of Article 6, paragraph 1 if an applicant falls outside the legal aid scheme because his or her income exceeds the financial criteria, provided, of course, the essence of the right of access to court is not impaired. The Strasbourg Court, which has to interpret a convention which applies to 47 very different high contracting parties, has consistently recognised the limited public funds which may be available to support civil actions, and has sought to work with such limitations while ensuring effective and fair access across those 47 very different states. In contrast, the legal aid provision of the European Union Charter reflects a procedural principle or right, and now, given the recent interpretation of Article 19, paragraph 1 of the TEU, it is directly or indirectly linked to the Article 2 value of the rule of law. In Deb, the Court of Justice pointed out that Article 47 is to be found under Title 6 of the Charter relating to justice, and not under Title 4 relating to solidarity, which is where most socio-economic charter principles are congregated. It remains to be seen whether classification as a procedural principle and harnessing the powerful EU principle of effectiveness in relation to it might make the right to legal aid in an EU context less susceptible to arguments concerning budgetary restraints. The Golder and Airy judgments on the right of access to court and the positive obligation on states to provide recourse to legal aid in certain civil cases are rightly regarded as groundbreaking judgments from the Strasbourg Court. For the law to develop, one needs not only independent and impartial courts established in accordance with law, but also litigants willing and able to challenge where necessary, where to seek to extend or limit the law's boundaries. These are the areas of the legal world. To register as a right, an entitlement must be capable of actually being exercised and enjoyed. The reality is that if meritorious cases are not being brought nationally or at European level for fear of financial and indeed financially ruinous consequences, then the organisation of justice in the broad sense, to borrow the terminology of the Court of Justice, may be in need of closer attention. The Strasbourg Court has proceeded at times boldly, but overall carefully, in weeding out restrictions which in effect impair the very essence of a party's right of access to court. It has proceeded in a fact-sensitive manner in individual cases, while laying down general principles which states must adhere to in their individual national systems, thereby embedding Convention principles in the 47 national systems to which it applies. It's worth rereading Airy. The roadmap laid down in that judgment was both remarkably clever and remarkably flexible. The approach of the Court of Justice of the European Union in the recent rule of law cases, where potential interference as a result of the manner in which a state has organised its justice system with EU values and the principle of effectiveness, have been the basis for the EU's legal responses, points to the possibility of a more systemic engagement with access and legal aid questions in the future in EU law. However, both as regards the European Convention on Human Rights and EU law, domestic courts and national legal systems remain the essential locus for the protection and enforcement of human rights, either because of the subsidiarity which underpins the Strasbourg system or because of the principles of direct effect and supremacy, which transform national judges into EU judges. The further access to justice potential of both European systems will in due course, I have no doubt, be tested by national courts and litigants, but how and when they do so will to a large extent be determined by their national access to justice. Before concluding, may I just say a few words in recognition of the contribution that Chief Justice has made. You'll have to listen to words like this, I'm sure, a lot in the coming 9 to 10 days, but I think all of those who deliver them with a heavy heart that you're leaving us, and also warm thanks. The Chief Justice has been a remarkable Chief Justice in the domestic courts and the domestic scene, but he has also been a very outward-looking European Chief Justice. He serves on the 255 EU law panel, which many of you will know. He's brought the Irish courts into the European Court of Human Rights Supreme Court network, and something which I think was not given sufficient attention was that pre-COVID, he was asked to open the Strasbourg judicial year in January 2020, an honour which I think the court wished to bestow on Ireland, but also on the Chief Justice personally. And I thank him very warmly. Ladies and gentlemen, many thanks for your patience, and I wish you the very best in your work during the weekend and well beyond. Thank you very much.
Thank you very much, Síofra, and for those kind words. I don't mind hearing them, and I don't mind hearing them again. Just one reflection on what we've just heard, given that we've a few moments. Obviously, the language used by Judge O'Leary was the careful language of a serving judge who may have to deal with some of these issues. While I am still technically a serving judge, I will not have to deal with any of these issues because the chances of any case getting to the Supreme Court in the next 9 days involving any of these matters is quite limited. But I think that has laid perhaps a roadmap, to echo one of the phrases which Judge O'Leary spoke about the Airy case, for the future development of the law in this jurisdiction. As you pointed out, most of it must start in domestic courts. We have the representatives of the two legal professions here who will doubtless bring such cases. But I think there is a great deal of food for thought about measures or cases that might be brought that might clarify some of the questions which you have identified. And I think it echoes a point I made in my opening speech this morning, which is that whatever about the moral or practical arguments within the Irish order for various measures to enhance access to justice, there also is a European dimension, which, if we are not careful with, could lead to us, whatever our own views, being subject to external binding measures from European institutions. And I think that's a dimension to the problem that we need to keep in mind. It's not something where we are entirely free to make up our own minds. We have to comply with our international obligations, or measures may be taken which will make us do so. So thank you very much for that contribution. Just as you said, when one goes back and reads Airy, one can see a flexible but clear path to the future. Perhaps some elements of what's just been said may in the future be something we can look back on as a roadmap that was taken up by those with an interest in this area and pursued, if necessary, through appropriate forms of litigation. We have managed, usually for most conferences, to get to the point of the break actually 10 minutes earlier, and I thank the speakers for that. But I think we will take the full break, and we will start again with Professor Farrow at 11:15. Thank you all very much. Okay. Well, welcome back to the second half of this plenary session. And the first speaker in this second part is Professor Trevor Farrow of Osgoode Hall Law School, and also chair of the Canadian Forum on Civil Justice. And as I mentioned in my opening address, one of the aspects that we need to consider is, leaving aside moral arguments, what are the practical consequences of addressing access to justice, and perhaps equally importantly, what are the practical consequences of failing to address access to justice? And I think there's no one better placed to be able to help us on that topic than Professor Farrow, to whom I now hand the floor. Professor Farrow, very glad you took the time to be with us this morning.
Good morning, and thank you, Chief Justice Clark. I trust you can all hear me.
Yeah, we can hear you well.
Terrific, thank you. And please let me add my congratulations to you for all of your contributions you've made to access to justice. And thank you to your court services and Law Society colleagues. It's a real pleasure and honor to be here with you this morning. It is great to be back in Dublin, although I must say the last time I was there a couple of years ago, it didn't involve a Zoom and computer screen. So I'm quite sorry that I'm not able to be there and that the pandemic doesn't allow me to be there in person. What I'll do now, I'm going to share my screen and take you through a couple of points for this morning's session on investing in justice. And really what I would like to do is cover three questions. The first is to ask, when we're talking about access to justice and a conference on access to justice, start with the question, what is at stake, or why should we care? Secondly, justice funding. We've had some conversation this morning from the Chief Justice and from the Minister about justice funding. And so I want to ask the question, is it a priority? And then third, look at the issue for the topic of the day, investing in justice, and does investing in justice make sense? So to the first question, what is at stake, or why should we care? It may sound intuitive, it may sound trite, it may sound ridiculous to ask the question, although I think the fact that we're at a conference on access to justice here this morning and similar conferences are taking place elsewhere perhaps yields an answer that if we do care, maybe we don't care enough. But in any event, why should we care? I'm going to start with outside looking in, but broadly put, when we look around the world, and I'm pointing now to the recent report of the Task Force on Justice, Justice for All, which reports from 2019 that approximately 5.1 billion, 2/3 of the world's population, lack meaningful access to justice. And when we look at other broad international studies, I'm thinking about the World Justice Project and elsewhere, all of these numbers start to come together. Now, big numbers, what does that mean? So a different way to look at this is to, rather than starting at 60,000 feet, go straight to the ground and ask people themselves and ask them what they're saying. So what I want to do now is to spend a few minutes on some research that I and others in Canada have been involved in over the past decade. And really what we've been working on are, in a nutshell, two main questions. What's the cost of delivering an effective justice system? And what is the cost if we do not deliver an effective justice system? And we've done numbers of different studies and different reports and what have you to try and look at around these questions, underlying which continues to come up. The question is, why do we care? So let's look at what the public's saying and telling us about justice. So let me start with our most recent Canadian legal needs study. And before I do, I'll just, by way of comparison, our Canadian population is approximately, it's a little more now, but 36 million, 37 million people. So you can get a sense by comparison with the Irish population. I also want to say that I'm going to talk about some Canadian legal needs numbers, but these numbers are very similar comparatively to other studies around the world, whether it's in the UK, Australia, elsewhere. And for those of you that are interested in understanding legal problems and how the public experiences problems, the World Justice Project has just literally a few weeks ago published the World Atlas of Everyday Legal Needs Studies. It's a terrific interactive tool that you can access to get a sense of the over 100 countries that have legal needs studies posted on that atlas, to get a sense of how people are experiencing justice. So with that, I'll take you back to Canada for the moment to give you a sense of how Canadians experience problems, but it's not because it's Canada that's relevant, it's because these numbers are very similar to others around the world. So approximately 50% of adult Canadians will experience a legal problem over any given 3-year period. That means approximately 11 million people or so over that period. Telescoping out, that's essentially all of us over the course of a lifetime. And within a 3-year period, adult Canadians will experience approximately 36 million separate legal problems. And that's in a country with the population of approximately 36 million. And so it's at this moment, if I'm talking to my law students who are increasingly concerned about what's the future of law and lawyering and what have you, when we talk about the concerns around access to justice, the volume of problems and the volume out there, it also can be a good news story, quite frankly, for the legal profession, in the sense that there is no lack of legal demand out there. Of course, the question is how to match that demand with that supply, but that's a different question, perhaps one for tomorrow. As I'm talking about these problems, the other thing to note is the kinds of problems. The largest typically is consumer problems, other problems including debt, neighbor problems, an increased number of racial-related problems, family law problems. Interestingly, the Chief Justice mentioned criminal law and criminal legal aid this morning. Similarly, I think across the common law world, criminal problems are by far the smallest number when we talk about everyday legal needs of a population. So when you think about how we invest in justice and where the money goes, that's another interesting gap to think about perhaps for tomorrow is, does it make sense to spend most of our money on the criminal side when where most people experience justice is actually on the civil and family side? But again, that's a question for a different time. So what about these problems? Cutting into them a little bit, there's tons we could say about legal problems. I'll just say a couple things. We know quite a bit about how people experience justice. For example, almost 60% of people experiencing one problem report experiencing more than one problem, which means that problems cascade. The more problems people have, the more problems people are likely to suffer. Housing problems lead to violence problems, lead to addiction problems, etc. Family problems lead to violence problems, lead to schooling problems, that sort of thing. Predictive variables around age, disability, number of children, education, employment, gender, income, etc. All of those are predictive variables on how people will experience justice and the amount of justice people will face, or problems, pardon me. And then, of course, justice does not, or put differently, lack of access to justice is not visited equally upon a population. There's a significant unequal distribution of justice problems across a society. Those with low income, vulnerable populations, marginal populations experience more problems. And while I don't have time to get into it now, there's a small but growing amount of research indicating that during the recent pandemic, none of these issues have done anything but expand over the course of that 18-month to 2-year period. So the pandemic has amplified the problems of justice and inequalities. So that sort of gives you a sense of the broad scope of numbers of legal problems. So how do people address their problems? And this is also not unique to Canada. This is very similar around legal needs studies around the world. It probably won't surprise people, but the vast majority of legal problems and experiences around justice occur outside of courts and tribunals and not with the assistance of lawyers. So a little over 7% of issues that people face when they report how they're dealing with those problems, only 7% of them bring them to courts and tribunals, and less than 20% access legal advice. So we start to see that gap between the volume of problems and the formal tools of justice, and noticing how people experience justice, where they experience justice. And then certain other avenues that people pursue, whether it's non-legal assistance, different community justice, intermediaries, that sort of thing, the internet. Most people, 75%, at least talk to the other party, try to address their problem with the other party. Friends and relatives are a big one. Now, I put this slide up not to suggest that courts and tribunals and legal advice are important. Quite the opposite, and I'll come back to the end. I happen to be a big proponent of the importance of public courts and tribunals and the importance of legal advice. And my next slide lends some support for that. So particularly on the legal advice front, when people report their experience of pursuing those avenues, when people get legal advice, they typically indicate that it has been extremely helpful. And so the idea that only 20% can access it, but more than 80% say that when they can, legal advice is extremely helpful, again, gives us food for thought about how we might think about support, where it's given, the value of legal aid and what have you, starts to give us a glimpse of where people are at when they report on the self-report on these issues. And then, of course, other issues, other reports on how other ways to deal with justice are reported as helpful or not, and you can see them there. For example, people accessing the internet, just over half say it was helpful. And so we can draw our conclusions from that. So what about cost? And this is a question that has only relatively recently emerged, surprisingly. And our 2016 legal needs study in Canada was one of the first ever to look at the direct question of cost and how people experience justice. So I told you that over a given 3-year period, about 11 million people experience a problem. What do Canadians spend on average per problem to deal with the issue? And by way of comparison, 1 Canadian dollar is approximately 0.8 US dollars or 0.6 euros. So when I did this research, what was reported back by those who responded was approximately $6,000 per problem. And it seemed like a lot of money to me, but I actually, quite frankly, had no idea whether that was a lot or a little by relative or comparative terms. So I did a little digging to figure out what do Canadians spend their money on other than justice. We have a public healthcare system. So unlike the US, health costs are somewhat deceptive when we look at these. So I haven't gone to health costs. But when I look at what Canadian households spend on average on food each year, which is about $8,000, a justice problem starts to become quite significant, almost as much as a household spends on food, or this is on average, or about half as much as Canadians spend average annually on shelter. So the number of $6,000 per problem starts to become quite significant. When we aggregate that, Canadians are spending, individuals I'm talking about, not corporations, almost $8 billion annually to deal with their everyday legal problems, and likely much more. And of course, that doesn't include other costs, vacation days, non-paid days to deal with their problems, searching problems, and what have you. Now, what about non-financial costs? And of course, we've looked at that, and a little over half of those who report experiencing a legal problem report increased stress or emotional problems, or as a direct result of legal problems. And they also, so health problems and also other social problems are reported. And so what do those look like? Well, when we asked people if by experiencing a legal problem, they also was a direct result to accessing social assistance or employment insurance as a result of experiencing at least one legal problem, many people told us that that was the case. Of course, then we asked, when you did experience a legal problem, how much more social assistance did you access? How much more employment insurance did you access? And those collected together was over $700 million annually, knock-on costs to our social and employment assistance schemes. What about healthcare? And this number is dramatically underreporting, because what we said to people was, if you experienced one legal problem, did you go did you visit a healthcare professional at least one more time as a result of experiencing that problem? Over 1 million, almost 2 million extra healthcare visits were reported annually. We then looked at the average cost per healthcare visit, which is about $60 or so, and that came up to a little over 100 million. Now, I told you that almost half of those people experience one problem had more than one problem, and we know that people who accessed healthcare once certainly accessed it more than once. So this number of 100 million is dramatically low, but we wanted it to be at least something certain that we could report. So this represents the floor, not the ceiling, of knock-on healthcare costs as a result of experiencing a legal problem to our Canadian social services. And then, of course, housing. I don't have an aggregate number, a dollar figure for you. We just didn't figure that out in a reliable way at the time we were doing this study. But we certainly found the percentage of Canadians that lost housing every year or relied on emergency shelters as a result of experiencing one legal problem. And so those are the knock-on costs, not just to individuals, but to the state of those experiencing justice problems and protracted justice issues. What about other costs before I leave this? And of course, there are other, what people might call soft costs. I hate that term because it makes it sound like it's not important, but there are issues around trust, exclusion, alienation. And so we did a study a couple of years ago in downtown Toronto, which is a metropolitan area about the size of Ireland. And we did a relatively small study asking people about their views on justice and access to justice. And what we found was a fairly significant sense of exclusion and alienation from the general population, talking about people on thinking about justice as related to money, to what lawyer you can afford, class. If you don't look good and don't have a suit, the judge just isn't going to hear your case. Immigrants are much more susceptible. Problems of language, education, culture, age, sexual orientation, poverty, etc. These are not small issues, because once the society starts to lose faith in the justice system, we know what happens to the rule of law. So when we talk about why do we care, I think the data and the research tells us why we should care. Having said that, if none of that is persuasive, I think we can just simply look around and think about whether everything is going so well at the moment. And if the question is, where is justice in all of these pieces of our lives? I think the question is, should we care and do we care, looms quite large. Secondly, is justice funding a priority? And I'm going to be quite quick here. The minister spoke about funding. Far be it for me to talk about funding in Ireland, but I can say comparatively that justice funding is a problem around the world. In Ontario, in the province that I live in, we think we have a terrific legal aid system, but to access it, someone needs to make less than $18,000 a year. And by way of comparison, the poverty line in Canada for a single adult is approximately $20,000 a year. So you have to be below the poverty line in order to access legal aid. And recently, 2 years ago, notwithstanding that challenging legal aid budget, our Ontario legal aid budget was cut by approximately 30%. And at the time, the former Attorney General's office released this statement: while some lawyers may not welcome renewed accountability at legal aid, every dollar saved is a dollar we can invest in services that matter most to people, such as public health and education. And I know the Chief Justice mentioned health and education in his opening remarks. And so those issues kind of loom large to me. And this was a remarkable statement to me for a number of reasons. But that was 2 years ago. If we look at the most recent Canadian election that just happened about 2 weeks ago, when the center spread of the national newspaper was opened the day before the election, all of the main election issues were trotted out. And in my mind, the main one that was not mentioned anywhere on the page, on anyone's platform, was justice. And again, I can't speak for the Irish context, but when I'm speaking with colleagues around the world, it is head-scratching the number of times that justice is not mentioned when we talk about big-ticket election issues or spending issues. However, when the public's asked about justice and access, and I go back to that study we did a couple of years ago, people seem to care about it. People think that justice is fundamentally important and should be as important as our healthcare system. And when we talk about people having a right to justice, almost universally, everyone says yes. So when our former Attorney General's office says that the issues that matter most are health and education, the data doesn't necessarily line up behind that. And I hope to persuade you that the investment data doesn't either. So let me get to that third question in my last few minutes. Does it make sense to invest in justice? 2 years ago, a colleague of mine and I did a report where we essentially looked around the world and looked at the main return on investment studies that people had done in different parts of the world to try and get a sense of what people are saying about investments in justice and whether it makes sense from an economic perspective, or put differently, when we look at it from a return on investment. Does a euro spent on legal aid yield a positive or negative return on that investment when we look at the overall impacts? And so this study was done in 2019. It was one of the first of its kind to do that. There's also a World Bank study that I commend to you as well. It's a different kind of study, but it comes up with similar results. And when we looked, so looking at some relevant places, what I would, when we think about legal aid, typically when I talk about dollars spent and dollars returned, what we found is that for every dollar spent on legal aid, there was a positive return on investment of somewhere between $9 and $16, give or take. And this was aggregating across dozens and dozens of studies in different jurisdictions across the United States, the UK, Scotland, Australia, and elsewhere. And this meant things like dollars spent on pro bono, family collaborative centers, mediation centers, youth justice centers, community legal centers in Australia, community-based paralegals in South Africa. One of my favorite studies was a study out of Bangladesh where there was actually a profit-making center in terms of collaborative social enterprises around investments in community justice. So there's lots of detail. The bottom line conclusion, though, is that there is a positive return on investment. Put differently, when we invest in justice, the investment, the benefit outweighs the investment. So when people say we can't afford to invest in justice, or when my former Attorney General's office say it's better spent elsewhere, the conclusion from this data is actually that we can't afford not to invest in justice. Other studies, ways of looking at this include methodologies around social return on investment, which is a more complicated, controversial way of looking at cost benefit. It's more of an assessment, an estimate about return on investment, thinking when you compare things to length of process, perceived fairness, satisfaction, future conflict, costs, and what have you. But a study that we collaborated on recently in Canada looked specifically in the area of family law, and again, finding interesting results around how different kinds of conflict, different kinds of processes yield different kinds of returns on investment. And not all processes are worth spending money on. For example, when you have a low conflict family law case, it's not always cost effective to go to litigation. It's actually quite costly to go to litigation. Whereas, for example, collaboration or mediation yield much better results. And so there's a sophistication in the data that you can look at to try and get a sense of where are we spending money, how are we spending it, and when does it make sense. Similar numbers for high conflicts disputes that are there. So where I want to finish now in my last minute or so, because I know that the purpose of tomorrow is to look in the context of roundtables and discussions about, I think the Chief Justice called it, thinking about a roadmap and what might come of this. And I think some takeaways from all of this. Our traditional approaches of justice focus on institutions, courts, tribunals, lawyers. Of course, those are fundamentally important to the workings of justice. And I, for one, happen to be, as I mentioned, a big proponent of public justice for all the reasons, for example, that Judge O'Leary talked about, and the reasons for why in a common law system we rely on a robust public court system. And one way to think about that is to try and get more good justice to more people through our public system, as opposed to less perfect justice to the few. But thinking about how to do that is challenging. But if we focus on a more meaningful approach to access to justice, we need to start with the people that use it, rather than starting with the institutions. How do people experience justice? What kinds of problems do they have? And what do they need? And then thinking about that more specifically, thinking about it, the kinds of problems that people have, the kinds of people that use this, recognizing that how people understand justice and how they get their matters, and that lots of the current systemic barriers, whether it's race, gender, immigration, dramatically aggravate people's ability to get to justice and to trust justice. Recognizing that we've got massive numbers of legal problems that are going unmet. The big part of the iceberg is just not being seen. So thinking big picture, trying to get upstream, get to problems early, allowing our courts to deal functionally with the problems they need to deal with, and getting those that don't need the courts out and to other paths. And then finally, understanding that the myth of saving money and justice, that we can somehow spend it elsewhere, just now does not bear out anymore when one looks at the data that is available to us. So when we come to that third question, does investing in justice make sense? As I said, what the data says is we just can't afford not to do it. And I think where I'll leave you is, when I come back to this and cut through the whole thing, solving justice does not seem that difficult. You know, if we can do some of these things, if we can land a human-made module on Mars, fly a helicopter and bring something back, solving the access to justice crisis does not seem like that big a deal. If we can experience a world pandemic, and then in the course of 12 months, somehow miraculously through the hard work of our healthcare professionals and our scientists, come up with a solution through a vaccine, the access to justice problem does not seem that challenging. I think the question now is, is the public aware of what the issues are? Are our politicians really engaged and aware and able to seriously address the problem? And then ultimately, can we put our creative juices to work? Because there are lots of great ideas out there. But I think at the moment, we are not taking this problem as seriously as we need to. And so that work around investment is absolutely critical if we're going to get anywhere on this file. With that, Chief Justice, I think I'll stop and turn the floor back to you. And I just want to again say thanks for including me. And I do wish you well with the deliberations tomorrow on this really important topic.
Thank you so much, Professor Farrow. I think you've added greatly to our understanding. Also, for those of us who advocate for greater access to justice, I think you've given us the data weapons that can be deployed in that debate. It's funny, one of the things I've always felt we've lost by not being able to meet in person are the discussions that happen on the fringes of conferences. One often learns as much over the cup of coffee at the break as one does, and it's a pity that only some of us have had that benefit. I'm glad to see you can have a cup of coffee, even if remotely. But it's very funny, just to echo one of the points you made. I was discussing with one of our participants here today over coffee during our break, something that has a close echo to what you were saying. One of the things I think we always feel in the courts is that the number of cases certainly in many areas, public law being a very good example, is itself dependent on what happens upstream. If you have better ways of solving the problem, then the cases don't have to come to court. And then the number of judges that are available can be better deployed dealing with the ones that just can't be resolved there. And I think that has echoes in very, very many systems. And certainly one of the big takeaways I've had from your talk is that we need to address this from the point where the problem arises to the point where it's solved. And that may not always mean that it has to get anywhere near a court. And it's better and probably cheaper and more effective for those where it can work, but it's solved somewhere else. But that too, thank you so much for that contribution. And I'm sure it'll make a great difference as an input to our deliberations tomorrow on the detail.
Thank you, Chief Justice.
Not at all. And thank you very much for being with us. And I'm sorry you weren't able to be with us in person, and maybe we'll have an opportunity to meet in the future. The final contributor is the Chief Executive of the Court Service, Angela Denning. I've expressed this concept in two different terms in recent times. I chaired the board that appointed Angela. I have sometimes said that was the best decision I ever made. I rather cruelly at my final meeting of the court service said it was the greatest mistake I've ever made. But I think people laughed at that because they knew it was a joke. But Angela came on board, I think it would be fair to say, with a mission given to her by us, but also a mission which she had herself, to be at the heart of modernising and reforming the court service. And while it isn't, as I said at the beginning, it isn't the whole answer, it's certainly part of the answer. So I give the floor to Angela.
Thank you very much, Chief Justice. Good morning, Minister, working group members, speakers and guests. Thank you very much for inviting me to speak today on the Court Services Modernisation Programme, which aims to improve access to justice in a modern digital Ireland. I'm particularly grateful for the opportunity to address an open forum such as this and to update you on our plans for the future. And I look forward to getting your feedback afterwards as well. We can't speak about the future without some context. Court systems play a critical role in society. Access to justice is an essential part of a well-functioning democracy. We saw this most recently during the pandemic, where the court's oversight role of public administration played a really vital role. The OECD have found that effective access to justice services is a crucial determinant of inclusive growth, citizen well-being, and that the rule of law, security and justice influence economic performance and business and investment climate. Countries with trusted justice systems report higher levels of GDP per capita, property protection rights and national competitiveness. Legal certainty, predictability and businesses' trust in justice systems help positive investment decisions and promotes competition. The Court Service is responsible for the management and administration of the courts in Ireland. The service has a unique role in supporting the third branch of government. Our work very much reflects, and I've said this before, what's going on in society at any given time. We run an operation the size of a small town every day. The figures speak for themselves. Last year, despite the pandemic, we dealt with 15,500 probate applications, 13,200 supervision and care orders for vulnerable children. We managed 1.98 billion of investments for over 2,500 wards of court. The district court alone dealt with 382,000 incoming offences out of 415,992 criminal matters. Our services are provided by 1,100 staff that operate in 33 court offices across the country. We support 19 county registrars and 176 judges, soon to be 181. We work alongside more than 20,500 solicitors and 2,300 barristers. Our spend last year was 155 million, including 32 million of fee income. The 103 court service venues are dispersed across the country and cater for communities ranging from 1,200 in the case of Kilronan and the Aran Islands to 1.37 million in the case of the Dublin Metropolitan District. So if we're doing all of this every day, why do we need to modernise? Well, firstly, user expectation. In the modern world, service users expect rapid access to high quality services. Digital technology has driven these expectations and traditional service models need to align or be redesigned to meet the needs of citizens and businesses. In response to these expectations, the modernisation of the Irish public sector has been a long-term government vision since the release of the first public service reform plan in 2011. The reform agenda is driven to establish Irish public services as user-centric, cost-effective, more cohesive and an exemplar of e-government. There's an increased emphasis on greater utilisation of technology and digital services to provide public services. The government's public service data strategy and public service IT strategy promotes the improved use of data as well as an IT and digitally enabled society so that more efficient, timely and simplified services can be provided to users. The Public Service Framework for Development and Innovation proposes a range of new approaches to service delivery in order to make public services more transparent, accountable and effective. Its aim is to strengthen public services in order to deliver better quality and outcomes for the Irish public. The Irish justice system is also experiencing significant change in its operations. The establishment of the Court of Appeal in 2014, a new structure and operating model in the Department of Justice, the establishment of the Judicial Council, the Commission on the Future of Policing, and the report on the reform of the civil administration of justice. The Family Courts Bill is the legislative platform to establish a dedicated and integrated family court that will redefine existing services, working practices and facilities. The criminal law reform continues via the Criminal Justice Hub. Best practice is another driver of change. The Irish court system strives to be regarded highly, not just in Ireland, but across the world. However, in relation to leading international jurisdictions, the Irish court service is well behind in designing user-centred services and leveraging the full potential of digital technology. Allied to this, an external organisational capability review published in 2019 identified areas where we could do significantly better. Since its establishment in 1999 as an independent organisation, the court service has modernised, but from inception, the court service has grappled with the need to manage fundamental problems in the current management system of the courts and the court system. With resources and investment focused on running the day-to-day operations of courts and maintaining a large estate of facilities, change and strategic improvement activities were for the most part ad hoc and poorly resourced. We needed to address the fact that the overall court system in Ireland performed unfavourably compared to international peers on a number of published benchmarks. A key aim of the court service is to be recognised as a leader in court management and operations, especially in the area of digital services. With many Irish public services now providing user-centred digital services and access to data in real time, the court service needs to invest heavily in user research to design services that will meet the increasing expectations of our users. For the court service, this reform agenda aligns with our strategic vision to 2030 of improving access to justice by redesigning traditional service models around the user and transitioning to digital services to increase efficiencies, timeliness, and thereby reduce cost. That capability review also found that at the time, our IT estate was a legacy of uneven strategy and inadequate investment, and these matters have to be addressed in a planned and consistent manner over the years ahead. IT in the court service requires particular attention because it was not resourced and configured to deliver effectively for the organisation across its key business functions. In particular, many features of its current IT systems are not fit for purpose. When I joined the central office in 1995, I was told that the IT system would be gone in a couple of years. We're still using it. Many of the features of our systems aren't fit for purpose and they're unsuited to manage and administer and deliver services in an efficient and effective manner. We have a fragmented IT landscape, multitude of systems that don't talk to each other. Outdated technology, we have unsupported systems which require significant investment if they're to provide the necessary support for the delivery of services and processes. The same report found that a range of other factors hampered modernisation, including, among other things, our reliance on the actions of other stakeholders in the court system to bring about some of the reforms needed, and legacy practices and behaviours that have existed for decades, which rendered the operation of the court system less effective than it could be otherwise, and on many occasions fragmented by geography or court jurisdiction. Now, following the recommendations of the OCR and the lessons from international peers, the Court Service Board and senior management team realised the need for a long-term strategy that would provide the time and investment to support a whole of system reform, driving behavioural and organisational change and delivering ambitious outcomes. In 2019, following extensive consultation, the Court Service Board approved a long-term, ambitious vision for the court service of the future. A vision of a modern, transparent and accessible court system that is quicker, easier to access and more efficient. The strategy sets out 7 objectives that the court service aims to deliver and support. We want to deliver just, user-centric services with a focus on accessibility, timely administration of justice, simplified services and process, integrated with our justice partners with a real emphasis on collaborative working, thereby delivering efficient and effective services and providing value for money to the taxpayer. We're seeking to improve services across 5 categories that align with the statutory mandate of the court service, thus ensuring that all facets of the court service are redesigned or refined to deliver user-centric services. The long-term vision outlines a whole system approach to service modernisation that will deliver benefits not just to the court service and its users, but to the broader justice and civil sector. We're adopting a prudent, phased implementation approach with the initial focus on building foundations and capabilities to enable our transformation. That building started at the top. We have a new management team with roles aligned to actually deliver the programme. We've recruited to bring in skills that we didn't have in-house, but we recognised we needed. A Chief Information Officer and Head of Data and Digital who started work on Monday as part of the significant strengthening of our IT unit, a Head of Communications to improve how we engage, a head of health and safety, he was very useful during the pandemic, a procurement specialist and a specialist knowledge manager to provide improved research and library facilities to the judiciary. We've recognised that we don't have all of the skills we need to undertake a transformation at the scale envisaged in-house, and so we've partnered with Deloitte for a 3-year period to assist the delivery. Part of that contract provides for the upskilling of our in-house change programme team so that we're less reliant on external support in later phases of the programme. We're spending a lot of taxpayers' money on this, so we have a very robust governance arrangement in place. Delivery of the programme is overseen by a committee of the board, which was established last year and is chaired by the Chief Justice. We've established an external advisory board comprising a judge from the Supreme Court of Victoria with significant court transformation experience, the lead of the Irish Public Service Reform Programme, a member of the UK Behavioural Insights team, and an Irish Public Sector Chief Information Officer with significant experience in the area of transformational change through digital. The programme is overseen by a dedicated division in our restructured organisation led by Audrey Leonard, Assistant Secretary. We've established 4 reform streams of work: family, civil, criminal and organisational. We've installed cross-functional teams, including very experienced operational staff, IT project managers, change programme project managers, with an emphasis on consultation and communication with users from the outset. We've changed the methodology for delivering our IT projects, you'll be glad to hear, to an agile way of working. Traditionally, we'd have gathered requirements, programmers would have gone away for a couple of years and built a system, it would be tested, and then inevitably it needed changes before it was used because things either got lost in translation, legislation or court procedures changed in the meantime, or indeed life had moved on in the interim. Now we will build quickly, go back for feedback and make changes on a much shorter time frame loop, thereby delivering new systems which people actually want to use much quicker. The Court Service IT unit faced a number of historic challenges, including recessionary budget cuts and resourcing restrictions, together with unexpected and competing demands for IT services and delivery. Within these constraints, the Office managed to maintain business as usual functions, deliver system upgrades and manage the design, build and implementation of a series of solutions. But to ready the organisation for delivering truly user-centric digital services, we're addressing a number of areas to enable IT to be more effective and to service increasing demands. We've increased the capacity and capability in the team. We've chosen a new architectural framework to support a fit-for-purpose future IT state. Our IT strategy has been published today, actually, and a data strategy will follow by the end of the year. Our legacy systems don't support data sharing, and I was very interested to see all the data that Professor Farrow had. Our existing systems limit data access and reporting. This was very evident during COVID, when myself and the management team had huge difficulty trying to get access to data to make decisions and to discuss with the Chief Justice and presidents of the jurisdictions things like waiting times and where the biggest backlogs were. The ability to assess the performance of the Irish justice system is limited by the fact that data for many core indicators, including the likes of the EU Justice Scorecard indicators, is not captured, either due to methodology differences or a lack of data availability. Many of the statistics published in our annual report are gathered manually, so we've recently established a dedicated unit to look at the type of information we need to capture in our systems to produce meaningful management information into the future. But you'll be glad to know modernisation isn't all about IT and statistics. It's primarily about people. Our aim is to take a very user-centred approach to everything we do. We've started to demonstrate this already with the wayfaring proof of concept complete in Orosí Dálaí, the introduction of child distraction areas in family law offices. We have a family court pilot underway in Limerick with wraparound services on site, and the Legal Aid Board have provided great assistance in this area. A new appointment system is being piloted in some Dublin and Limerick offices so that people know what time they'll be seen at a public counter, how long they'll be there and how much money they need to put in the parking meter outside. Our new website has 3 million hits a year and is fully accessible and more user-friendly than its predecessor, though we have more to do. I've sought funding in the budget this year for a plain English expert to work on our website so that people who have literacy challenges will find our information easier to navigate, bearing in mind that the same website has to serve legal professionals, but the average reading age of an adult in Ireland is 9. 1 in 6 adults in Ireland can't read a bus timetable, so we have to meet that challenge with people who use our services every day. We're increasing our use of video and infographics on our website and in our communications. On foot of a suggestion from our staff in our innovation scheme, we've recently become a jam-friendly organisation. Jam card allows people with a learning difficulty, autism or a communication difficulty to tell others they need just a minute extra, discreetly and easily. It's a little card you carry in your wallet, and 75% of our staff have undergone training in recent weeks to make us jam-friendly. So far, so good. And then we get to March 2020 and the pandemic. And like court systems worldwide, we were thrown into a massive experiment. And like all crises, it gave us an opportunity to accelerate some changes, which would have happened anyway, but undoubtedly would have taken a lot longer, and to try out some things that we would not have imagined weeks earlier. As a common law jurisdiction, we focus on precedent, we're guided by the past. We believe, rightly or wrongly, that what came before is inherently better and more trustworthy than some uncertain future innovation. We prefer slow, steady change, and we got big bang change instead. For the past 18 months, our aim was and is to protect the health and well-being of employees, judges and court users while continuing to provide access to justice. We succeeded in providing a safe environment through the use of a robust safety management programme while adapting quickly and maximising the numbers of cases we could progress within public health guidelines. Physical distancing requirements in particular had a dramatic effect on our operating environment. The court services provided in-person and remote facilities throughout the pandemic, with a particular focus on prioritising urgent business and those who are most vulnerable, such as victims of domestic abuse. I'm particularly proud of our participation in the Justice-wide Still Here campaign and of the commitment and dedication shown by our staff by continuing to provide access to justice at a time when the country was almost entirely shut down. We adopted a digital-first approach throughout the pandemic. Rather than use a traditional checklist to manage compliance in buildings, our 90 local safety representatives used iAuditor on their mobile phones to complete regular checks, thereby providing instant data back to our health and safety team and allowing us to respond quickly where there were issues in courthouses. We also had to change how we communicated. We're aware that 96% of Irish people carry a mobile phone, so we moved to use social media and Twitter in particular to get messages directly to court users. We had facilities to take evidence from prison by video link prior to the pandemic. However, this dramatically increased during the pandemic. We now do more video links per month than we did a year pre-COVID. This has had significant benefits across the justice system, not just in terms of cost. Movement of prisoners to court has had a significant impact on prison life, with training and education disrupted as prisoners often have to overnight in another facility before a court appearance or spend long periods of time travelling to and from court. We're now piloting the technology with some Garda stations in Dublin. The introduction of remote courts has changed how we work. Our platform is a world leader in interoperability so that users don't need particular kit or software to participate. It's not the fanciest, but it's free to the user, simple to use for those who are not at ease with technology, and it works from any phone or device. It's not perfect, but remote courts are the worst they are ever going to be today. They will only improve. And we have seen an increased demand from certain witnesses to provide testimony remotely, thereby eliminating costly travel time and time wasted waiting to give evidence. We've seen a demand to continue straightforward administrative work remotely. Remote courts also remove some of the unseen barriers to justice for those with physical disabilities and for those in poverty. The cost of childcare, time off work, travel expenses, car parking, and appropriate clothing. We've seen increased participation in some types of proceedings, such as insolvency, where participants can just dial in. Chief Justice McCormick in Michigan spoke recently about courts being less intimidating on screen. She said that when you're in the comfort of your own home, where you feel safe and secure, it's easier to feel confident in letting the court know what's on your mind. She said everybody's Zoom box is the same kind of size. There's something equalising about that. She also said that losing a bit of decorum is a small price to pay for increasing access. Victim Support informed the Oireachtas Committee on Justice this week that measures taken in courts during the pandemic, which positively improved the experience for their clients, included the staggering of lists so there was less waiting around to give evidence, lower numbers of people in the courthouse, and the use of technology. To meet the challenges of the future and demand for new means of providing access to justice, we're well underway to completing a €2.2 million investment in the installation of video technology to provide 103 video-enabled courtrooms by the end of the year. One of the significant challenges for us over the past 18 months, and a challenge indeed to digitisation, is our over-reliance on paper-based systems and on travelling to buildings to deliver paper. We introduced ShareFile to help with this, but we need to continue to reduce our reliance on paper. Court systems worldwide are now at a post-COVID crossroads. The big question for me is how to bring the benefits with us so as to best deliver for court users. I'd like to retain the innovation and agility we demonstrated. We've shown we can do things differently without impacting the quality of justice in many types of proceedings. In seeking to reduce wait times and procedural delays, enhance user experience and reduce costs, the court service is targeting ambitious improvements that are well beyond our ability to deliver independently. To realise the full benefits of this system-wide approach will require dialogue and collaboration with a broad range of stakeholders. Ultimately, we want to benefit our service users and will be dependent on them to join us on the journey. Excellent communication and engagement from the outset is key to the uptake of newly redesigned services. We've started this already with our engagement in relation to the design of Hammond Lane, which will be our dedicated family law centre in Dublin. Our family law reform team have consulted with a large number of stakeholders, including public family law users, staff, judges, practitioners, service providers, state agencies and NGOs who assist families in relation to the future state design of a model family law building, and fed the results back then to the OPW design team working on the building to influence how the building will best work for those who use it. We've had a really positive experience and response and received fantastic insights in relation to all aspects of the building. Public users have told us that the building should be less intimidating, less cramped, with better signage and bigger waiting areas to provide more privacy. None of this is rocket science, but by engaging this way, we now have the knowledge to take an evidence-based approach as we move forward. This new need for stakeholder engagement ranges from working side by side to designing new service models to ensuring legislative changes are appropriately assessed for their impact on the court service, users and the broader justice system. Lessons from previous projects have shown the risks of not engaging stakeholders, poor adoption of new processes and systems, delayed legislation halting planned improvements, and a lack of alignment with other change initiatives. The court service consulted with stakeholders from across the sector during the development of our long-term strategic vision. However, this was very much the first step in what needs to be the establishment of a coalition of willing reformers committed to working with us to modernise the court system. In designing our initial programme to deliver the court service long-term vision, key elements are our comprehensive stakeholder engagement strategy, robust governance structure with stakeholder representation, and transparent, regular communications with key contacts, groups and organisations. As you're aware, our group was established, chaired by President Peter Kelly, to report to the Minister for Justice and make recommendations for changes with a view to improving access to civil justice in the state, promoting early resolution of disputes, reducing the cost of litigation, creating more responsive and proportionate system, and ensuring better outcomes for court users. Our civil reform team are working with the Department of Justice on the implementation plan for the recommendations. One area we're giving particular attention to is the streamlining and standardisation of forms. We have almost 50 forms to apply for maintenance in Ireland and 900 forms on the civil side of the house. We simply cannot expect people who cannot afford legal representation to have to deal with such complexity. One area we're prioritising in the short term is the system for the recovery of debt in Ireland, which is currently very cumbersome and complex and entirely paper-based. This makes the recovery of even small levels of debt relatively expensive. The cost of that is pushed onto the consumer. Small businesses owed money cannot recover that quickly and at a reasonable cost and encounter unnecessary liquidity challenges. Our aim is to streamline the process first and then digitise end to end. This should have a knock-on then in areas like conveyancing, where at the moment credit searches have to be done manually in books in the central office. So hopefully that will improve. The court service has outlined an ambitious long-term strategic vision to 2030 that will fundamentally alter the organisation and how it meets the changing needs of its users. The long-term strategy aims to align us with the broader justice and civil reform programmes that will deliver a modern digital Irish public service for citizens and business. No one element exists in isolation from other parts of the system. There are a wide range of interdependencies between all elements of the system. The court service has a significant role to play in helping to create conditions conducive to a more effective court system. In addition to those matters it can control, the court service will have to work collaboratively with other stakeholders if it's to help and support those changes and reforms that will contribute to an effective and efficient system. We interact with a diverse and complex range of users across a range of services and channels daily. The current experience of those users is one marked by frustration. The significant cost of court cases, the wait times and duration of procedures, delays in accessing required information, the need to travel to access and deliver hard copy documents. This experience is in part due to a system that has evolved over time around the needs of the system and the court service, rather than the needs of users. The extent to which many of these reforms actually happen is outside the sole and immediate control of the court service. Achieving a more effective and efficient system requires all of the elements working together in common purpose. Moving forward, we need to play an enabling and supportive role at the heart of a collaborative effort across many parties to deliver a step change in the performance of the court system. One of the pillars of reform under the programme is the provision of modern estate facilities with a rationalised estate, concentrating sittings in fewer venues, the development of specialist centres and investment in modern facilities to support court users. It's our ambition over the course of the programme to reduce the requirement to attend at court offices and courthouses through the improved use of digital services designed to best serve users. An estate strategy will be developed underpinned by data, including demographics, caseload, distances between courthouse, public transport infrastructure and travel times. Our estate strategy will also be impacted by the Family Court Bill, which aims to provide regional dedicated family courts, and by our experience during the pandemic. Future decisions about courthouses will be influenced by the spatial planning framework and spatial strategy and by policy on climate and environment. The large variation in community type and size we serve in our courthouses directly impacts on venue utilisation. In terms of wait time across the country, there's a significant variation across circuit and district courts. Wait times are strongly aligned with demand and capacity mismatches. And we're very conscious that extended wait times can have a significant impact for individuals and businesses. A properly planned estate should assist with the reduction of wait times. We know that given the age of our estate, our courthouses are an average of 162 years old. It'll be a significant challenge to meet environmental targets, and we've particularly to get all of our buildings to B rate by 2030. We've established a dedicated sustainability unit, which has recently been expanded to face the challenge ahead. I want to just finish by saying that the OECD research on the areas of access to justice has told us that common barriers to accessing justice range from financial cost, time, the complexity of the justice system, to geographic distance, lack of legal capacity and language skills. Our modernisation programme seeks to assist litigants by addressing each of these barriers, thereby breaking the cycle of decline caused by unmet justice needs. The inability to access justice can both be a result of and a cause of disadvantage and poverty. We need to rethink the traditional approaches to delivering services by making those services more personal to the individual and to their situation. Choice is key. It's my intention that our modernisation programme will provide just user the innovation and agility we've demonstrated over the past 18 months by collaborating with users and by keeping the needs and requirements of litigants at the centre of everything we do. Lastly, I want to thank the Chief Justice for his leadership of our modernisation programme. He has driven our progress to date. His legacy will include remote and hybrid hearings, and most importantly, will surely be the improvements ordinary people will see when they interact with the courts in the future, thanks to the road you have set us on. Thank you very much.
Thank you very much, Angela. The programme says I'm to sum up at this stage and say a few things. I'd like to start by saying a number of thank yous. It has been a great pleasure to work with each of the members of the working group, all of whom are assembled in the room here, so I see them grinning happily. I think we worked very well as a team. Every side asked to contribute came on board straight away. FLAC, Legal Aid Board, the Law Society, and can I thank the President for, as they used to say, the use of the hall, and also providing the IT infrastructure, which the one thing you can't really judge when you're in the room is whether it's all looking well outside, but my spies tell me that it has worked very well, and it's a credit to the team you've built here in Blackwall Place and the Bar Council for their major contribution. When we come to tomorrow, it's worth reflecting as part of that thanks that the way we decided to deal with the workshops was to give each of the contributors the job of minding one of them. And they all seem to me, at least, to happen seamlessly. Speakers were arranged, ideas were put forward about what the gaps might be in the speaking programme, and the proof of the pudding will obviously be in its eating tomorrow. But I think each of those workshops has the capacity to bring a detailed approach to specific aspects of the problems that have been identified as part of a more general picture here today. And last but not least, I'd like to thank my old friend and colleague, Mr. Justice John McMenamin, who took over effectively chairing the group as soon as we got to the first meeting where I got shoveled out and he took charge. I've known John for, unfortunately, more than 50 years. I think he's about to be relieved by the fact that me beating up my colleagues on the Supreme Court to make them more efficient is about to end, but I'm not sure things will be more benign under the leadership of Mr. Justice O'Donnell. So I start by saying thank you to everyone. The second thing I'd like to say is that the picture that all of the contributions that have been made today paints is one which I would have expected, but which has been coloured in to a much greater extent than perhaps even I might have hoped. I think it did demonstrate that there are a whole series of moving parts that can't work without other bits. As Angela said, there's a huge desire to modernise the court system, but it needs funding. That requires the support of the Department of Justice and the skilled ability of that department to persuade the Department of Public Expenditure and Reform to take out the checkbook and provide the money. And I do appreciate that isn't always the easiest task in the world, given the number of mouths they have to feed. But equally, new legislation and new government programs are fine. But if the people on the ground aren't implementing them, then they will not achieve what they're meant to achieve. One of the striking things, I think, was the realization which came over from Professor Farrow's talk, that we really need to look at this not just as a court-oriented issue, but all the other elements that bring resolution to issues that arise where there may be a legal solution to the problem. And interestingly, to hark on one of the points Angela mentioned, if we think about the whole project behind the Hammond Square development, I think that's a good example of how an integrated approach can significantly improve access to justice. Before I was Chief Justice, my predecessor, Susan Denham, appointed me to the initial board that was involved in the planning of Hammond Lane. And even the big picture physical design took on board the fact that ideally family law cases shouldn't have to go to a court at all. Now, clearly some will, and courts have to be the backstop, and I'll come back to that in a moment. But the building was really in its initial manifestation, and it had to be redesigned because the money wasn't there to do what we really wanted to do, but we'll do a good enough job, I think, at the end of the day. But even the way the building was designed was that one side was where people would go first, and where they would get legal advice from the Legal Aid Board, and they could have mediation to try and solve their problems. And hopefully a lot of the people who come in the door would go to the left side and wouldn't have to go anywhere else because their problems would be resolved. And I've always felt that of all the areas, perhaps two curiously disparate areas, family law and commercial law, are the ones that most benefit by mediation, because they often involve situations where people have to get on afterwards. The court can't sit micromanaging every bit of a family. Courts can resolve disputes where they can't otherwise be resolved. But in truth, if people aren't getting on, at least to the extent that they can handle things, you can't be going in every Sunday to say, oh, it didn't get me access yesterday. You need a system that delivers a sufficient working relationship that things can go ahead. And funny enough, the same with business. A mediated solution that leaves everyone going away a bit happy is more likely to lead to there not being problems in the future. So that was the idea of Hammond Lane, and I think it perhaps provides a template, if not in a physical sense, for what we need to do. We need to look at ways of providing a legal solution before you have to get to a court at all, so as to reduce the burden on courts and allow the courts to do what they have to do. And then have a proper court system where those mediated or other solutions just don't happen. And I do see courts, at least to some extent, as something that always has to be in the back of your mind, because ultimately people will think, well, if we don't resolve this here, what happens next? And if we don't resolve it here, it'll go to a court. And what will happen if it goes to a court? And if you feel you don't have access to that court, then that will affect what you do today in the mediation. So even though hopefully many disputes don't have to get to a court to provide justice, and access to justice can be provided without getting to a court, you always have to have in the back of your mind the backstop of what will happen if that doesn't work, and an effective court system that is there to solve the problem if it can't. I think what we've heard today has given us the big picture framework within which the detailed considerations of the workshops tomorrow will operate. Don't think today has given us the solutions. It's given us, firstly, I think most importantly, the reason why we have to find solutions. And to echo Professor Farrow's words, the cost of not finding solutions is going to be greater than the cost of providing for the solutions, even on an economic basis, if you leave aside altogether the social and other costs of unresolved legal issues. But how to solve things at a very detailed level does require expertise. It does require a lot of thought. I was very struck by the fact that a lot of solutions that are imposed from the outside on the legal system over the years have actually turned out to be worse than the problem they tried to solve. I think it needs that sort of collaborative approach, a bit like the interactive approach to IT that Angela mentioned. I mean, all of us, I think, have seen systems where you say, I'd like one of these, and the IT people go away and they produce something and it doesn't do what you wanted to do. It does perhaps what they think you wanted it to do, but there isn't sufficient interaction to know what will really work and what will really deliver the answers that you need. And I think that applies on a bigger picture outside IT. We all need a sort of an iterative approach where things are explored, where people who are likely to be involved, whether as lawyers, whether as judges, whether as administrators, or whether as the people who are ultimately availing of the service of access to justice are concerned. How will this really work on the ground? Does it look great on paper but doesn't deliver? My perspective as a judge might be to say, oh, that looks grand, we can do that. But someone may be able to say, well, actually that might seem grand to you, but it won't actually work in practice, or it won't actually deliver what you think it would deliver. And that's why I think this has to be a collaborative project. And that's why I sought to involve initially the small working group who I see before me today, but also why we're trying to involve tomorrow a much wider group of people who can bring different perspectives, ones we don't have, can challenge our perspectives, and hopefully come up with perhaps a more detailed roadmap. I was again struck by one point that Angela made just now. I've always thought that one of the difficulties we have in the legal system is a bit like the difficulty of building a motorway. There's two places you may build a motorway. One is along the exact route of the existing road, and one is a nice kind of greenfield route that goes somewhere different. The second is much easier. You just build it, and at the end you connect it up at both ends to whatever other roads are there. The first is a lot more difficult because you have to keep the road open while you're trying to build the extra lanes. And I think that we're, unfortunately, by definition, in that kind of situation. We can't shut down the justice system for 4 years while we build a nice new shiny one. We have to keep it going while we are developing. And one of the resources issues that Angela mentioned is one that's become apparent to me in my court service board chair sense, which is, the first call on resources has to be to keep the show on the road. And that's something we absolutely learned in spades during the pandemic. And therefore, if there isn't anything spare, there aren't the resources to do the new road that you need, because you do have to keep the road open. And I think that has connotations in a much wider sense. We have to ensure that we at least don't let things get worse in certain areas while we're trying to make them better in others. And that's why I think the devil is inevitably going to be in the detail. And that's the topic of tomorrow's workshops. So can I thank everyone who has attended? great to see that we've had such large numbers. I've got a little number on the screen here that shows me exactly how many people are online at any given time, and it's always being well over 250. That's a remarkable attendance, and one which I think shows the widespread interest in this topic. And can I just suggest that I welcome you all back tomorrow for whatever workshops you have chosen to sign up to. So thank you all very much for your attendance. And once again, thanks to those who were in the room who put so much effort into making this what it has been. Thanks very much.